Damn, lawyers have to act fast. Team Mentirosa is clapping back. Hello, my fam. It is Perez, the queen of all media, the original influencer, and your number one source for everything It Ends With Us saga. I told you earlier today that Team Baldoni Wayfarer filed a motion with the court asking the judge to compel Blakey Crocker to release her medical records to them. This information about what, if any, treatment she received for the emotional distress that she suffered at the hands of predator Justin Baldoni is a very important factor in the lawsuit. Or was. We're in the discovery phase, and Baldoni's team of lawyers that are highly paid were planning their defense against these claims of emotional distress. But after Team Baldoni informed the Lip Nibbler's lawyers that they were going to request this information, they said, hold your horses. You know what? Even though we cried loudly and made bold claims in our amended complaint, we're now going to retract that. We are withdrawing the claims of emotional distress, negligent and intentional infliction of emotional distress. Let's pretend for the case of this lawsuit, it never happened. Therefore, you have no access to her medical records. However, the two sides could not agree on how to achieve this goal of withdrawing her claims. Team Sexy Poppy wanted the claims withdrawn with prejudice, meaning if she withdraws the claims with prejudice, she can't bring them up again ever. But lawyers for the basement manager said, no, we're not going to give you the relevant information that in similar cases is given and that you're asking for now when it's supposed to be asked in discovery. We're going to withdraw our claims, but without prejudice. So at a later time, even though you are not going to have access to this information that you can have, are entitled to, and is relevant, at a later time, we might bring up these claims again. Understandably, Team Baha'i Faith was not happy with that, so that led us to today's letter to the judge. After the letter was submitted, the sexy, flirty, yummy chanteuses lawyers accused Team Baldoni of publicity stunting in their own statement to the press. And now, Fakely's legal team has submitted their own letter to Judge Lyman. Dated today, it says, Dear Judge Lyman, on behalf of our client, Blake Lively, we respectfully oppose the motion to compel and related filings by the Wayfarer parties earlier today. Given that the motion is a false and plainly improper public relations stunt, Miss Lively further requests that the court deny and strike the motion pursuant to its inherent power to control material on its docket that is abusive or otherwise improper under the circumstances. No, they had absolutely valid reasons for filing that motion to compel. Nice try. Miss Lively respectfully submits that the court may wish to consider sanctions for the continued abuse of this court's docket. As I shared with you all in the video I posted just before this, earlier today, Team Baldoni also is requesting sanctions against them. We see your sanctions and raise them. The just filed letter from Cesspool's wife says, quote, the motion was filed for a single audience, the media. There is nothing for this court to compel. As the Wayfarer parties make abundantly clear in their motion, Miss Lively voluntarily agreed to withdraw her infliction of emotional distress claims on Friday, May 30th. Miss Lively did so in good faith to streamline the dispute in the ordinary litigation process, given the damages she otherwise anticipates recovering. Pause. Withdrawing her claims is not standard operating procedure. It's not. However, they continue. Counsel for the Wayfarer parties concede and are aware that this renders their discovery moot, her withdrawing her complaints of emotional distress. But they also have been desperately searching for an angle to make a show out of Miss Lively's decision to streamline her case. Given this, counsel for the Wayfarer parties attempted to seize on the parties' agreement as to Miss Lively's withdrawal as a basis for this frivolous motion. Pause. As I and the Baldoni parties explained in the letter to the judge, the whole with and without prejudice thing kind of was really important here. The Woody Allen apologist does not bring that up in her letter to the judge. At least she hasn't yet. Maybe that'll change. The letter continues, quote, on Friday, counsel for the Wayfarer parties proposed a stipulation to dismiss Miss Lively's 10th and 11th causes of action for intentional and negligent infliction of emotional distress, respectively. Miss Lively's counsel provided proposed edits to the stipulation on Sunday evening after receiving repeated emails on Friday, late Saturday evening, and early on Sunday morning, falsely and disingenuously claiming that Miss Lively was refusing to participate in discovery by not immediately responding in the middle of the night, apparently, and threatening to advise the court. Oh, it's starting to get nasty. The Wayfarer parties offered no basis whatsoever for their unnecessary escalation of a mutually agreeable streamlining of claims or why finalizing the method of dismissal could not wait until Monday morning. That seems sensible. Nonetheless, in an effort to diffuse the situation and avoid unnecessarily burdening the court, Miss Lively agreed to the stipulated dismissal and proposed modest revisions to the parties' joint stipulation for dismissal on Sunday evening. In conveying the revisions, counsel for Miss Lively offered to meet and confer regarding any dispute as to the language of the stipulation, including on the parties' then forthcoming telephone conference scheduled for Monday afternoon at 4:30 p.m. Eastern. Counsel for the Wayfarer parties, including Mr. Fritz as signatory on the motion, attended the teleconference and did not address the stipulation. To be clear, at no point during the conference did they object or raise to any concern regarding Miss Lively's proposed revisions to the stipulation. Instead, they rushed to this court to file this clearly pre-written motion the minute that the teleconference concluded. Almost immediately thereafter, tabloid media began reporting exclusively on Miss Lively's shock move, claiming that she has sensationally dropped her IED claim, quoting extensively from the motion. They're making some solid points. The Wayfarer party's motion should be denied and further should be struck. It is based on two brazenly false assertions. First, they claim that Miss Lively has refused to disclose medical and mental health information, but as counsel for the Wayfarer parties concede, that information is relevant only to Miss Lively's stand-alone, tort-based emotional distress claims that she indicated she was withdrawing. Furthermore, the motion seeks to improperly compel documents that the Wayfarer parties lack a legal basis to obtain. Because the Wayfarer parties concede that Miss Lively has agreed to dismiss the 10th and 11th causes of action to which such discovery is solely directed, and they have agreed to the dismissal and proposed a joint stipulation to that effect, the motion does not legitimately seek any form of relief. As with the Friedman letter that this court previously struck, the one about Taylor Swift, the apparent intent of the motion is to launder their public relations narrative into the press by abusing the court's docket. So they're asking the judge to strike the motion as unnecessary, improper, and abusive. And reminding the court it may also wish to issue sanctions. And lastly, they're asking the judge to dismiss her claims without prejudice. Fire day. Ooh, thoughts? Let's discuss in the comments.